Officially, Jeremy Hogan shocked the court with his speech. Is it possible to relist XRP on Coinbase? What will such an event lead to? We will answer these questions in today's video. The current price of XRP for today is $0.35 and the trading volume for 24 hours is $136,000,000 We are updating our XRP price in US dollars in real time. XRP has dropped 30% in the last 24 hours. Welcome to the Rich Club channel. If you like this video, don't forget to like it and subscribe to the channel. Do you think the analysts are right about XRP? Write the answers in the comments. Giving away 500 XRP at the end of the week. One random subscriber will receive XRP coins. Take a look at the instructions in the comments section. All you need to do is write the word XRP, watch the video to the end to like and subscribe. The Relative Strength Index, RSI, has not been definitive over the past few days. Last week, the RSI held a neutral value of 50 as support, but recently this level has not passed. Thus, there may be some volatile dynamics during the weekend. Similarly, the Awesome Oscillator, AO, was also below zero. He has not yet shown a strong bearish impulse. The A/D line had a resistance zone that was directly overhead and was indicated by two dotted white lines. If A/D can overcome this region, it will be a sign of sustained demand for the XRP rally. The Directional Movement Index, DMI, showed the absence of a strong trend. ADX, yellow, it was at level 20, ADI just above the 20 mark. Technically, this indicated a bearish trend, but in general meant the absence of a significant trend over the past few days. The $0.35-$0.36 range will be important to protect the bulls over the next day or two. The formation of a lower low below this area will signal bearish strength. Momentum indicators were inconclusive on the lower timeframes. Bitcoin could also strongly influence the direction of XRP in the near future. Amici Curiae, led by attorney John Deaton, filed a response to the Securities and Exchange Commission's motion asking the court to ban Amici from participating in the upcoming Dober test. The letter came a week after the SEC demanded that the court reject Amici's motion to participate in the lawsuit and dismiss attorney John Deaton for gross misconduct. Recall that the SEC previously asked the court to deprive Deaton's lawyer of Amici status in a lawsuit for making public the name of one of its experts. The Securities and Exchange Commission noted that Deaton's actions led to a number of threats and intimidation of the expert. This prompted the SEC to request the sealing of the identifying information of its other experts to prevent a repeat. Deaton defends his actions by discussing key issues related to the case. According to Deaton's lawyer, before he revealed the name of the SEC expert, the parties in the lawsuit, Ripple and the SEC, had previously identified another SEC witness before filing the motion. I never imagined that there would be problems with the second SEC expert, and I should not have expected this, especially given that the parties disclosed the identity of the other expert, Deaton's lawyer said. The lawyer also added that he publicly condemned all threats and harassment against the SEC expert. Deaton's lawyer criticized the U.S. Securities and Exchange Commission for its hypocritical position regarding the expert's reports. According to Deaton, the SEC previously provided the same expert report to some XRP holders who sued Ripple, alleging that XRP sales violated U.S. securities law. The SEC has willingly provided an expert report to XRP holders because its position coincides with their position, Deaton added. The diametrically opposed legal positions of the Securities and Exchange Commission are consistent with Judge Netburn's sharp but accurate remark that the Securities and Exchange Commission takes its judicial positions to achieve its goal, and not out of loyalty to the law, said lawyer Deaton. Deaton's lawyer also accused the SEC of sacrificing its reputation to achieve its goal of depriving Amici of its status and banning him from participating in the lawsuit. He noted that the Securities and Exchange Commission intends to deprive Amici of the rights to a lawsuit, because the filing of the final court decision is not far off. Meanwhile, Deaton's lawyer went over William Hinman, the former director of the SEC's Corporate Finance Department, again. Amici Curiae's lawyer discussed Hinman's conflict of interest during his time at the SEC. Recall that Empower Oversight shared information about how Hinman blatantly ignored a direct command from the ethics office not to meet with his Ethereum-related Simpson Thatcher. As expected, the response of Deaton's lawyer to the SEC caused a violent reaction from the Ripple community. Attorney Jeremy Hogan, a partner at the law firm Hogan, praising Deaton, said, Deaton's response may be my favorite report on the Ripple case at the moment. He defends his position on the case, defends his actions, attacks the SEC and attacks the SEC expert, and it's all on 4 pages. And it also happens that it spills onto Hinman and his attitude to Ethereum. Bravo! Brad Garlinghouse, CEO of Ripple, discussed a number of cryptocurrency-related topics with Axios fintech reporter Lucian at Collision 2022. Garlinghouse touched on an important topic, the ongoing litigation between Ripple and the Securities and Exchange Commission, SEC. The CEO of Ripple expressed optimism that the blockchain company will win the lawsuit. According to Garlinghouse, his confidence stems from the fact that the law and other facts support the company's argument that XRP is not a security. I bet Ripple will win the lawsuit, just to be clear. I bet on it not only because of the tone of the judge's questions. I'm betting on it because I know the facts are on our side. I'm betting on it because the law is on our side, Garlinghouse said in an interview. However, the SEC is still pushing for Ripple's XRP to be classified as a security, Garlinghouse said. The SEC has gone too far, and they are trying to seize jurisdiction over something. I think they saw this gray area, confirming the argument that XRP is a security, and decided to enter, Garlinghouse added. Shin then asked Garlinghouse what would happen if Ripple didn't win the lawsuit. Garlinghouse noted that the company behaves as if it has already lost the lawsuit. Moments after Ripple was charged, trading platforms in the U.S. suspended XRP trading, fearing that the SEC might pursue them for facilitating the exchange of assets of this class. If Ripple loses the case, will anything change? It's the status quo. Ripple is still growing fast, he said. Garlinghouse said the Securities and Exchange Commission has control only in the United States, which has affected XRP trading in the country. At the moment, Mir is behaving as if Ripple has lost the lawsuit, although this is not the case, he added. American exchanges, including Coinbase, stopped supporting XRP immediately after Ripple was written off, which led to a sharp drop in the price of the coin. The SEC has jurisdiction only in the United States. In a sense, if you think about how the world works now, it seems that the case is lost. The lawsuit, which has been going on for more than a year, is considered the largest litigation involving the SEC that has ever occurred in the cryptocurrency industry. This month, Ripple recorded a major victory after Judge Sarah Netburn ordered the SEC to provide emails to William Hinman's speech in 2018. The blockchain company believes that the drafts of the speech will help its defense of fair notification that XRP is not a security. However, the SEC does not want to hand over Hinman's documents to Ripple, and now wants to appeal the order issued by Judge Netburn. The SEC and Ripple litigation seems to be entering a decisive phase after the last appeal of the first. The regulatory body filed a motion for a 30-page summary and a 10-page response to object to Judge Torres' decision on the draft speeches. As previously reported, Judge Torres ordered the SEC to disclose drafts of Hinman's speech from 2018. In the SEC's battle against Ripple, the SEC's latest proposal was partially accepted by Judge Torres. She ordered the SEC to file only a 20-page briefing, but provided a 10-page response to the subsequent proceedings. The regulator was hoping for a 30-page memorandum because it was instructed to object to 3 separate orders in one briefing. Meanwhile, Ripple has opposed both of these claims, as stated in court documents. The defendants here believe that all 3 orders relate to the same motion regarding Hinman's speech. Moving on to the short answer, the SEC has yet to see the opposite of Ripple's briefing. Consequently, Ripple also opposes the SEC's request for an extended response. Their motion went on to say that the SEC's requests are completely unfounded and biased. Recently, another important event became known in this case. The SEC asked Judge Torres to revoke the amici status granted to XRP holders and exclude John Deaton from the case. Ripple's defense team objected to this letter. James K. Phelan stated that Ripple's letter indicates that the SEC wants amici/XRP holders to be completely excluded from the case. The decision on Hinman's speech definitely cornered the SEC. They face a serious challenge to answer these questions with increasing attention on social media. It is unclear how long they will be able to delay the disclosure of documents. As for Ripple, they seem to be landing in a safe place in light of recent moves. What do you think are the prospects for XRP in 2023? Write your forecasts in the comments. Thank you for watching this video to the end. Please do not forget to like it and subscribe to the channel so as not to miss the release of new videos, and do not forget about our contest. Write in the XRP comments to add 500 XRP to your account.